You can't, while you're negotiating the most important treaty that this country has had, ever probably, you can't remove Parliament as a constraint, as a scrutinising body. That was the principle. This was a legal issue. This wasn't a political issue. This was a legal question about constitutional principle, and politics had to be left out of it. Lady Hale began by saying the judgment of the court is unanimous. There was a gasp, an audible gasp from the packed court. This was astonishing. The only precedent I could think of was the television series Dallas, where it's revealed that the previous episodes had all been a terrible dream.
You are listening to Inside the Case, brought to you by the University of Law.
We can now say the decision taken in 1975 by this country to join the common market has been reversed by this referendum to leave the EU.
Let June the 23rd go down in our history as our Independence Day.
10 years ago, the UK voted to leave the European Union. The process of what became known as Brexit led to two landmark legal challenges in the UK Supreme Court. They prompted two of the most constitutionally significant rulings in recent history and reshaped the power balance between the government, Parliament and the courts. Both cases were brought by Gina Miller, a city financier and businesswoman, and they became known as Miller 1 and Miller 2. The first challenged the government over whether it could trigger Brexit without parliamentary approval. The second challenged Prime Minister Boris Johnson over whether he acted lawfully in proroguing Parliament, bypassing parliamentary scrutiny of the Brexit deal. It was one of the most turbulent and highly charged periods in British politics. In both cases, the KC acting for Gina Miller was Lord David Pannick. Arguably the most influential barrister of his generation, he has acted in more than 100 cases in the Supreme Court and its predecessor, the House of Lords. In 1978, after gaining a first-class degree in law at Hertford College, Oxford, he achieved the rare and prestigious distinction of being made a Fellow of All Souls, Oxford, and a year later was called to the bar. There he developed a highly successful practice in public law, becoming a QC at the age of only 36. He was appointed a life peer in 2008 and took his seat in the Lords as a crossbencher, where he is an active participant in debates. I began by asking Lord Pannick why he opted for a career in the law.
Well, I had no family background in the law. My father owned a shoe shop in Romford Market, and my mother was a school secretary. But I enjoyed debating at school, Bancroft School in Woodford Green, and I was quite good at it. And I thought law would be an entertaining way of earning a living. I was an odd teenager because I used to go to the Old Bailey to watch criminal trials.
That is unusual. Were there quite a few of you, or did you have siblings?
I've got a sister, yeah.
Yes.
Yeah, but she's not a lawyer.
No. And what did your parents make of that? I mean, did they think this was a strange...
They encouraged me.
They encouraged you. They were pleased about it.
Yeah, they were very pleased. Yeah, they thought that being a lawyer was a respectable profession.
Yes, but I mean, did it require money, and did you have money as a family?
My parents were not wealthy.
No.
I won a scholarship to Bancroft School, and when I was at university, they were happy days because I was on a full grant, and a full grant meant you lived like a lord. And in those days, when you went to the bar, as well as scholarships, which I was fortunate to win, the local authority paid my fees. All of that, of course, is now a distant memory for students.
It certainly is. And just a bit more on your family and your father. So was your father born in this country?
Yes. My ancestors came from Poland and Russia at the beginning of the 20th century. They weren't refugees, but they were Jewish people who came to this country for a better life and who valued the values of this country and valued education. And they wanted the best for their children.
So you went up to Oxford, and how did you find it there? Did you?
Oh, I loved it. Yeah, I enjoyed it enormously. I had great fun. I worked very hard. I debated, not altogether wholly successfully. I was on the standing committee of the Oxford Union, and I was a Liberal Democrat, and I worked very hard, and I got a good degree.
Are you still a Liberal Democrat?
No, I'm a crossbencher.
Very wise. So we won't go into. We might come to politics later. So you then came out of Oxford, and you did very well, obviously, as we've said, and you then went to the bar, and you had a very successful career and took silk at a very early age. I think it was said you were the youngest in the land to get silk. Was it 36?
36, yes.
And you then developed what became a very successful practice in public law. Whose chambers did you go into initially?
Well, it was called Two Hare Court, and it had Anthony Lester, who did many human rights discrimination cases, and Michael Beloff, who was my pupil master. I started off in Chancery Chambers because I knew at Oxford the daughter of a Chancery judge, Lord Justice Dillon, but I didn't enjoy it. And I told Michael Beloff's father, who I knew,
Max Beloff,
Professor Max Beloff, and he said, well, you must come and work with my son Michael. He does interesting law. And he did sports law, did discrimination law, judicial reviews, which were developing. So I got in at the ground stage of the development of modern public law. This is 1980.
You found that obviously far more challenging and interesting.
Yeah, much more interesting.
Wasn't as dry.
Well, my first case at the bar was as the second junior to Anthony Lester in the Judicial Committee of the Privy Council. And it was a case from Singapore. Our client had been sentenced to death for drug trafficking. And it was an appeal about the constitutionality of that sentence. And it was fascinating. And we lost. And my first client was hanged. And you can only, only improve after that.
So you went on, and I think at some point you did move chambers to Blackstone, or Blackstone was
Well, the Two Hare Court became Blackstone.
That's
we
right.
moved because we were growing, expanding. We needed new premises, so we moved across the Temple.
And then, obviously, as we know, you developed this highly successful practice. Can you remember the first case you took in the House of Lords, as it then was?
Oh my goodness, it's a long time ago. I mean, I've done a lot of cases in the Appellate Committee, as it then was, before it became the Supreme Court. I did a lot of cases for the government because I was on a panel of Crown Counsel, and I did a lot of cases for applicants. So by the time of the Gina Miller case, I was very familiar with that context, with that forum.
I mean, by then, is it right to say that you had done more than 100 cases in either the House of Lords, as it then was, or the Supreme Court, as it
yes,
then was set up to be?
Yeah.
So
many,
you were
many as a junior. I mean, I didn't argue them all. I was sitting behind barristers learning, seeing them get roughed up by members of the Appellate Committee.
So the case of Gina Miller came to you. Can you remember meeting her for the first time?
Yes. I mean, what happened was that I knew James Libson, who was the solicitor for Gina Miller at Mishcon de Rea. And I'd also written an article in my law column in the Times, which you, of course, expertly edited over many years. And it was an article saying that the government could not decide to leave the EU without an Act of Parliament. There'd been, as you know, in June 2016, there'd been nearly 10 years ago, astonishingly, there was a referendum, people voted to leave, but the question was, did there need then to be another Act of Parliament? Because the Referendum Act did not say anything about the consequences of a decision to leave.
The process of it hadn't been discussed.
So Tom Hickman, another barrister in these chambers, and I were instructed by James Libson on behalf of Gina Miller, and we met to discuss the case. And she was a very brave woman, is a very brave woman, because by that time, there was newspaper speculation that she was going to bring these proceedings, and she was subjected to enormous online abuse. I mean, one
even
man,
at that early stage.
yes, rightfully, it got worse as the case got more publicity, as the case came to court. There was one man who said it was a joke, but she understandably took it seriously. He said that he'd pay £5,000 to anyone who ran her over, and he was sent to prison. He went to prison for 12 weeks. And that was just
horrific.
It was an
Yes.
extreme example, but there was a lot of very unpleasant abuse directed at her, directed at Mishkons, not at me, thankfully, but the consequence was that there were going to be other claimants, people who were going to support the claim, being named applicants, and they withdrew. They withdrew because...
So she was left then to carry it on her own,
yes,
was she?
Yes.
And she was at that time, or maybe she was a campaigner, but she was a businesswoman in her
Indeed,
own right.
yeah.
And so you met her, and how did you find her? Was she very forceful? What was she like?
Yeah, she was very forceful, very reasonable.
And clear in her view.
Yes, I mean, she took the view this, which it was a matter of considerable principle. She obviously didn't agree with leaving the EU, but she took the view if we were going to leave, it had to be as the result of a parliamentary act.
Parliament had to approve it. Parliament had to agree it.
Yeah, and that was the issue in the case.
So did she have strong views about how she thought the case should be run by you?
Well, she wanted the case to be presented as forcefully as possible, but she was an excellent client in that she was prepared to be the figurehead. She expressed very helpful views on the way the case should be run, but she wisely left it to the lawyers to get on and do it. She contributed to the drafting, but she had the political nous, she had the willingness to go ahead, but she left the lawyers to get on with it.
So you then came into the High Court, and that was the first ruling on it, wasn't it?
Yes, I mean, the referendum was in June. We started proceedings in July 2016, and by, I think, September, we were in court, which was speedy for British legal proceedings. But the courts recognised this was an urgent matter and it needed to be resolved. And there was enormous press attention, public attention for the divisional court proceedings. The High Court sat with 3 judges, given the importance of the case. They were the Lord Chief Justice, Lord Thomas, there was the Master of the Rolls, Sir Terence Etherton, and there was another Court of Appeal, Lord Justice Sales, who's since become Deputy President of the Supreme Court. So it was a very strong court that was appointed.
It was a very high-profile, politically charged atmosphere at the time, wasn't it?
Yes, it was, because many people took the view that the decision in the referendum was unwise, to put it moderately. And this was a big political decision. It was a challenge to the way that the government was proceeding. It was the government of Theresa May.
And they thought that you as the lawyers and Gina Miller as the applicant or person behind it, were trying to stop Brexit.
Yes,
that was what the view that the public, some of the public thought.
Well, certainly the case, if successful, would have caused a pause. It would have required Parliament to think about the implications and about whether it did want to press the button and withdraw from the EU. The difficulty in the divisional court as a matter of presentation was that there were no cameras in the court. And that, I fear, had a very damaging effect on the way in which the public and the press treated the judgment, because we won.
Yes,
the divisional court held that the government was acting unlawfully. It couldn't just say to the EU, "We are withdrawing."
No, and there was quite a strong media reaction and public and political reaction.
Well, it was an extraordinary media reaction. The media reaction from some newspapers were was that the judges were, quote, enemies of the people.
Yes.
And your people are entitled to criticise court judgments, but it was personalised. It was very abusive, aggressive. Lord Thomas said that in all his many years of experience as a judge, he'd never known anything like it.
He was the Lord Chief Justice at the
he was
time,
the
and
Lord
he was
Chief-
leading the court in that case.
And the judges required police protection because people were online saying such terrible things about them. Normally, what you would expect in such a situation would be that the Lord Chancellor would step in, because it was her job. It was Liz Truss. Whatever happened to her? Question mark. One doesn't know. But she was the Lord Chancellor, and it was her job to mediate between court and politicians and public, and to say clearly and forcefully, we believe in the independence of the judiciary. We don't necessarily agree with them. There's a right of appeal. We'll take it to the Supreme Court. But she was very mealy-mouthed.
She was quite slow, I think, in her response, which caused great upset amongst the judges. What did you feel about the reaction? I mean, you can't have had another case that had such a reaction as that one.
No, well, the publicity before the case was enormous, far more than any case I'd ever done before. And the public reaction afterwards was the volume of the publicity and the extreme nature of the hostility. And as I was indicating, I think part of the problem was that the public had not been able to see on screen what was going on. So they didn't understand, and who can blame them, that the issue in the court was not the merits or otherwise of us leaving the EU. The issue was an issue of constitutional law, that it's not for the government to make such a profound decision. It's for Parliament to decide. And the legal argument was very simple, that in 1972, an Act of Parliament had led us into the EU, had created all sorts of rights and duties, and we said, and the court agreed, it therefore required another Act of Parliament to decide that we were going to leave, and it wasn't good enough to have a referendum.
And obviously you did persuade them, and the case went on up to the Supreme Court. But just before we leave the divisional court, how did you personally feel? I mean, was it alarming? Were you worried? Did you have phone calls and things like that? And,
no, I don't think
threats?
I had any abuse or threats, happily. The abuse, the threats were focused on the judges, on Gina Miller, on Mishcon Durea. Not on me.
How did she feel about it? Was she deterred?
Well, she was delighted that we had succeeded, but obviously felt vulnerable. She needed protection. She
Yes,
had
as you said,
security guards following her around. And it was,
Pretty
it was
alarming.
unpleasant.
Pretty
Yeah, it was
unpleasant and alarming. So you get up to the Supreme Court, and as you've mentioned a couple of times, one of the key differences there, obviously, was that it was going to be shown on camera, live streamed. So what do you think the main difference of that was then? That people then
people could see what the issues were. They could see that this was an objective court that was not politically partisan, and that the issue was an issue of constitutional law. And they could, if we did our job properly, they could, if they watched and if it was reported, as it was, perfectly properly, people could understand the nature of the issue, that this was a question of parliamentary sovereignty, which people believe in, and that the executive, the Prime Minister, doesn't have untrammelled power. She needs to obtain the authority of Parliament for the dramatic step that she was taking, which was to remove us from the EU with all the legal consequences that follow. And that's what the debate was in the Supreme Court.
So they decided by 8-3. Were you concerned? Was it ever in doubt, or how did you feel about
it was in
way it
doubt
went?
to the extent that some of the judges, as was manifest from the fact that 3 dissented, asked penetrating questions, And it wasn't an easy issue because traditionally foreign policy is a matter for the executive. And the argument essentially for the Crown was that this was an aspect of foreign policy. We were withdrawing from a treaty, and therefore that's a matter for government. But no, I thought we had the majority. The most publicity during the hearing was devoted to an exchange that I had with Lady Hale, who was the Deputy President, because I cited a case, the Attorney General against De Keyser's Royal Hotel, and Lady Hale intervened. She said, well, it's not De Keyser, it's De Keyser. And I said, you say De Keyser and I say De Keyser. And given the low standard of legal humour, this was thought to be riotously funny. And everybody laughed.
Finally, there was a joke.
There was a joke which broke the tension.
Yes.
And what I didn't do, I thought about it afterwards, what I didn't do, perhaps wisely, was go on to say that this, of course, is taken from the Ira Gershwin lyric, you say tomato, I say tomato, and it comes from the song, the Gershwin song, Let's Call the Whole Thing Off. And I think it would have been unwise to
prolong the analogy.
In the context of Brexit, that would not have been helpful. But it did lead to some enterprising barristers for charity producing T-shirts with my picture on, and the slogan was De Keyser, De Geezer, something like that.
You became something of a celebrity online, I think, in social media.
For 5 minutes, yes.
Did your family buy the T-shirt?
Andy Warhol's principle that everybody is famous for 5 minutes. Yes, my children did buy the T-shirt. It's somewhere in a cupboard, locked away, I think. Probably the Pannick family bought the majority of those T-shirts.
I mean, I think
that were sold. But it lightened up what was otherwise quite a dry set of proceedings. And people could watch it. They saw it, and millions of people did watch it.
They did indeed. And did Lady Hale find it funny?
Yes.
Your joke?
Yes, she found it funny. Even Lord Sumption laughed, and that's quite something.
Well, that is indeed.
Yeah.
How, just finishing on the interjections by the Supreme Court justices, did he intervene much? Was he difficult? Because, of course, you'd acted opposite him before he became a judge.
Lord Sumption?
Yes,
yeah,
many
Lord
a
Sumption,
time.
yes.
He was an old, long-standing rival of yours. You'd often appeared opposite each other.
We did cases against each other. But he did intervene, and he made it very clear during the hearing by his questions that he thought that Parliament would need to intervene if we were to leave the EU. So his vote in the majority was no surprise. He made it very clear what his views were during the hearing, as did many of the judges. Lord Neuberger, I think, did not reveal his hand. He was the president then of the Supreme Court.
Did he write the judgment?
Well, the 8 of them in the majority had a joint judgment, and there were dissenting judgments as well.
Given the difference that you think having cameras made to people's reaction and understanding of the whole issue, do you think we should have cameras more widely in courts than we do now?
Well, all of the cases, or at least most of the cases in the Supreme Court, are available for broadcasting.
They are. I'm thinking lower down.
Yeah, lower down, of course. There are obvious difficulties with criminal trials, with witnesses, with juries. But by and large, yes, I'm very strongly in favour of cameras in court. I think transparency is very important, and I think that it assists public understanding of the issues that come up in courts. Many of the issues are issues of public importance, and it's quite right that people should be allowed to see. I should add, of course, that if you're an advocate or a judge, you very quickly forget that cameras are there. I mean, you do your job, you present your case, you judge the case. So I don't think it affects people's performance.
That was always the fear, wasn't it?
That's not my experience. Is that you forget very quickly.
So what were the consequences of that particular ruling before we get to the next one?
Well, the consequences of the ruling were, from the point of view of those opposed to Brexit, very disappointing, because within a couple of months, Parliament had been presented with a bill by Theresa May's government, and Parliament voted in favour of leaving the EU. So it held up the process. I think it was damaging to Theresa May's government, and she then suffered for the next 2 years attempts to implement the leaving of the EU. So it was damaging to that extent, but it didn't have a major impact on the process of leaving, because Parliament did what the court said was necessary.
Just got on with it and then did it,
and it wasn't really very. There were many people in Parliament who were strongly opposed, but the political argument was a very strong one. We'd had a referendum, people had voted in favour of leaving, so therefore we left.
Yes. Did you, obviously you had your own view about it. May I ask what it was?
Well, my view is I voted to stay in the EU.
So did you find it then difficult or not? In fact, it probably helped to bring this case, which you supported. You were sympathetic.
Well, not really. I mean, I have a very firm principle at the bar. I act for people whether I approve of them or I don't approve of them. I act for people whether I like them, I don't like them, whether they cause me offence or whether I'm neutral. And whichever it is, I get on and I do my job. My job is to present their case, not to express my personal views. So it doesn't really affect me.
So just 2 years later then, Boris Johnson by this time was now Prime Minister. Theresa May had been effectively ousted.
Yeah, well, Theresa May was unable, because of the lack of a working majority on this issue in the House of Commons, she was unable to do a deal. She was unable to take us out. And so she fell. Boris Johnson became Prime Minister, and he made it very clear early on in his premiership that if he needed to, he would prorogue, that is, suspend Parliament, to remove the inconvenience, the difficulty of having the House of Commons breathing down his neck. And he would suspend Parliament so he could, in his words, get the deal done, get Brexit done.
So you knew that this was in the pipeline or likely to happen?
Yeah, well, he became Prime Minister in the summer of 2019, early summer. And from that point on, the team, that's Mish Cons, James Libson, Gina Miller, Tom Hickman and I, we were preparing because we knew that there was at least a real possibility that Boris Johnson would prorogue, suspend Parliament. And we took the view that that would be unlawful, that you can't suspend Parliament because Parliament is an inconvenience to the wish of the executive to do a deal with the EU. So over the summer, early summer, we were preparing a case. I also met Sir John Major, who was represented by my friend Edward Garnier QC, because he wanted to participate in the case, which he did. He became an intervener and helpfully made submissions through his counsel at the hearing.
So you just waited basically for the suspension, the prorogation
but we
to be
didn't know
announced.
if or when it would come, but we were preparing. And I was on holiday. I was on at the end of a family holiday on safari in Botswana, where the communications were not all they might be, but the message came through. Boris Johnson has sent Jacob Rees-Mogg and others to Scotland to advise Her Majesty that she should prorogue Parliament, and in accordance with constitutional principles she'd acted on that advice, and Parliament was being prorogued for 5 weeks, which was unprecedented.
Yes.
And
so did you cut short your holiday?
No, I was at the end of the holiday. We came back on the plane. I worked on the plane. We filed our judicial review application within a week, and the case was heard very, very speedily, I think a week after I returned, by the by the High Court, by the Divisional
Court,
Yeah.
the High Court.
Yeah.
And just before we come to that, in parallel at that, there was also a challenge in the Scottish courts.
Yeah, it was a
wasn't there, going
similar
on?
challenge brought by Joanna Cherry, MP,
Yes.
along similar lines, that you, the executive, Boris Johnson, you can't suspend Parliament in order to stop them from scrutinising what you're up to.
This time it didn't go quite so well
No,
for you.
it didn't. It went badly because they decided that this essentially was a political issue. It was not a legal issue, and therefore the court it was not justiciable. In other words, it was not a subject that admitted of legal assessment, and therefore we failed. Case booted out unceremoniously. Disappointing.
Yes.
But we knew this case would go to the Supreme Court, so it was a temporary blip.
Temporary setback.
And it was even less of a serious matter because at the same time, the Scottish court reached the opposite conclusion. They reached the conclusion that not merely was this issue justiciable, but Boris Johnson had acted unlawfully. So the Supreme Court, to which these two cases went, heard both cases at the same time in the same hearing. We had 3 days allocated, I think within a week or so of the divisional.
It was very quick.
It was enormously quick. The reason it was so quick was it had to be because Parliament had been suspended, and it had been suspended for 5 weeks. And Boris Johnson was negotiating with the Europeans to try to get the deal done, and Parliament was neutered. Parliament couldn't have a say.
Yes.
So we needed the case to be heard speedily, because if we were right, then Parliament should come back.
The Scottish one, I think you had a word with the council when it all came up to the Supreme Court, and you emphasised to them this was a constitutional, not a political
Well, I made the point
issue.
Which was the correct point, that our only chance of winning in the Supreme Court was to satisfy the justices, again there were 11 of them, that this was a legal issue. This wasn't a political issue. This was a legal question about constitutional principle, and politics had to be left out of it. Unfortunately, after I'd made my submissions, Aidan O'Neill, who was the counsel for Joanna Cherry, adopted a different approach. I will remember, it was early in his submissions, he told the Supreme Court, and I quote, "Boris Johnson works in the mother of parliaments and he is the father of lies." The court was quite surprised.
It's a rather good quote. Not the sort of thing they hear in the Supreme Court.
Indeed. And then he quoted from the speeches of Nelson Mandela and Mahatma Gandhi and various others.
Quite colourful.
It was a very colourful. As I say, I think the Supreme Court did not necessarily find this the most helpful approach. And if you look in the official law reports of the case, none of this appears. The editor of the law reports didn't report all this, but it didn't matter.
It didn't affect the argument.
It was very entertaining, but not the line that was most likely to succeed.
Could I just ask you, they were unanimous in the Divisional Court. Were you surprised at their decision, and did you think they had some kind of a case? I mean, clearly they were at one on it.
Well, I wasn't surprised because it was clear in the Divisional Court what the judges thought, and they were very troubled by it. Of course, they had an argument, and that argument was very powerfully deployed, as in the first case in the Supreme Court, by their counsel, particularly Sir James Eadie. Their argument was that it is a matter for the prerogative of the Prime Minister whether to prorogue Parliament, and there'd never been a case where the courts had intervened in relation to such a matter. To which, of course, our answer was there'd never been a Prime Minister who had, in our submission, so abused the power to suspend Parliament, and therefore the court should intervene. We said, as we said in the first case, This is a matter of constitutional principle, the principle being the sovereignty of Parliament, that the executive cannot remove the constraint that the Constitution imposes upon the executive through Parliament. You can't, while you're negotiating the most important treaty that this country has had ever probably, you can't remove Parliament as a constraint, as a scrutinising body. That was the principle.
And you had another factor in your favour in that the government side failed to produce any evidence.
Yes, well, it was a remarkable feature because part of our case was that there's no explanation from the government as to why, in an unprecedented manner, Parliament was being prorogued, suspended for 5 weeks. In all previous cases...
Do you mean why it was being prorogued at all, or why it was being prorogued for 5 weeks as a period of time?
It's common for Parliament to be suspended in between sessions of Parliament, but not for 5 weeks.
And so, not in the middle of a session.
And not in the middle of a session. So this was unprecedented. And there was no evidence explaining why. And there were very strong rumours, they're only rumours, but very strong rumours, that no civil servant, to their great credit, was prepared to produce a witness statement that did not give an accurate description of why there had been a prorogation for 5 weeks. So there was no witness statement addressing that question.
And did they answer the question why there was no witness statement?
Well, not really. And it was one aspect of my reply to the government's submissions, emphasising that point. I mean, the hearing was very interesting because I began the hearing by saying to the Supreme Court that we had 2 arguments. The first was that the suspension of Parliament was for an improper motive. And the second argument was that the suspension of Parliament had an unlawful effect in that it prevented Parliament from sitting. And Lord Reid, Robert Reid, who was then the Deputy President of the Court, is now, of course, the President of the Supreme Court, intervened. And he said, well, of course, if you're right on unlawful effect, we don't need to address the motives, whatever they were, of the Prime Minister, to which I gratefully grasped the olive branch and said, yes, well, that's correct. And then I focused my submissions on the effect. But it was a very strong indication
of the way they were thinking.
Yes, that the court was interested in whether or not this decision was unlawful because of its effect on the parliamentary process.
Yes.
And that's what we pursued, and that's what they decided.
Well, before I come to the decision itself, obviously this was another massively high-profile case.
Yeah.
Thousands of people watching it. Did you find it daunting? Do you find it daunting, or to stand up in a case like that? Were you nervous?
Well, I'm always nervous. Cases advocacy is nerve-wracking because you don't know what's going to happen, however much preparation you do. But happily, for most advocates, and certainly for me, once you start, the adrenaline kicks in and you focus on doing the case. But yes, it's very nerve-wracking leading up to the case, and it's particularly nerve-wracking when you know that so much attention here, and you say thousands, but it's, people around the world watched it, hundreds of thousands of people, and there was newspaper speculation, articles, acres of it, about what each judge was like and what their record was and what they were likely to decide. All of it nonsense, of course, but enormous attention being put on this case. People coming up to me in the street wishing me good luck.
Did they ask for your autograph?
Well, after the case, I had the experience that I've never had in any case in my 45 years at the bar of someone in pret-a-manger asking me for a selfie. I did have that, which is certainly unusual.
The high point of your career.
Yeah, indeed.
You obviously had a feel that it was going well, had gone quite well. Lord Reid had made a helpful intervention, but you can't have been sure, and even you can't have expected came out with some astonishment, an 11-0 judgment in your favour.
Yeah.
Tell me about that.
Well, we had 3 days in court,
Yes.
and it went very well. And the court reserved its judgment, adjourned, and said they'd give us their judgment the following week. And they came back on the Tuesday, and we didn't know what they were going to decide. We had no advance notice. Normally, you get given a draft judgment in advance, but not here for obvious reasons.
Quite.
And we were all sitting in court, packed court, and Lady Hale, who was by then the president of the court, began her judgment, and she began by saying, she summarised the judgment of the court is unanimous. And there was a gasp, an audible gasp from the packed court. And she went on to explain not merely that the case was justiciable, not merely that the government had acted unlawfully, but also that it was as if Parliament had never been prorogued. Parliament had not lawfully been prorogued. And this was astonishing. I mean, this was an astonishing result for all of us. The only precedent I could think of was the television series Dallas, where it's revealed that the previous episodes had all been involving the death of Bobby Ewing, had all been a terrible dream. You know? So you should go back in time. And the consequence was that the next day, the Speaker of the House of Commons and the Speaker of the House of Lords called Parliament back, and Parliament went back to work and scrutinising what the government was up to. So it was astonishing.
Astonishing. I think everybody wondered whether there'd been a bit of arm twisting. I mean, did Lady Hale have to lean on her colleagues?
I think it's highly unlikely. It's highly unlikely because they're all very strong-minded individuals, men and women. They all have firm views. They weren't going to sign up to a judgment unless they believed in it. And indeed, as we've discussed, the first Miller 1 was 8-3. You know, there was no press ganging there. So I think that they all formed that view.
Well, you must have been delighted as a personal level. It was quite a success, wasn't it? Quite a triumph.
Well, it's very rare to have a case, two cases, in which everything goes right. I can assure you, I've had my share of cases where that was not true. They're too painful, many of them, to discuss, but I've had my share of losses. Every barrister wins some and loses some. This was particularly satisfying.
Yes. So, and as you said, the political consequences, Parliament was as it had never been suspended. It went back to sitting.
I mean, the consequences, immediate consequences, it was very damaging to the government of Boris Johnson. I mean, his reputation was, I think, enormously damaged, although it didn't prevent him from winning the election in December 2019 by a substantial majority. And he got Brexit done, in his words. So, you know, there was a limited political impact. What I think it did was to deter government, remind government that they needed to act lawfully, and remind government that there were consequences in terms of reputational damage. If they didn't act lawfully, they would be taken to court and they would lose. I think it was also caused a rift in relations between number 10 Downing Street and the Palace, because Her Majesty and the Palace were embarrassed by this, that Her Majesty the Queen had been given duff advice by the government. She'd been asked to prorogue Parliament, she'd done her duty, and it had all gone badly wrong. I collect cartoons of my cases, and I've got on my wall a cartoon. It's by Nick Newman, published in the Sunday Times, and it's a cartoon of a scene at the Palace, and a flunky is bringing a telephone. The telephone's ringing, and it's a flunky is presenting it to Her Majesty, and she's saying, "If that's Boris Johnson again, tell him I'm not in."
It's great, isn't it? Great cartoon. And actually, Boris Johnson clearly didn't bear a grudge against you, did he? We
No,
know
he
that
didn't.
because he went on to instruct you.
Yes, he did. I mean, he, a couple of years later, as Prime Minister, was brought before the House of Commons Privileges Committee, and he was accused of lying to Parliament, not telling the truth in Parliament about COVID parties at Number 10. And he very kindly instructed me, and I was very happy to be instructed because, as I say, I like doing important cases, and I'll advise and act for whoever.
And what was he like? Was he
Well, he
quite
was
friendly?
a model client. He worked hard on the case. He was, of course, highly entertaining. He was committed to the case, and I enjoyed working with him. It was a very frustrating experience because in the House of Commons Privileges Committee, counsel are entitled to appear and sit near their client, but you're not allowed to speak. And for counsel, that is a very, very frustrating experience.
Yes, indeed. I mean, he was actually found wanting in that committee report.
Yes, he was. He was.
Nonetheless, you perhaps mitigated to the best you could.
I did my job, yes.
So looking back on those two Brexit cases, and obviously a high point in your career, what do you take from them? What will you remember about them?
Well, what I'll remember is that the highest courts in the land asserted constitutional principle. They did so against the executive. They upheld the role of Parliament, the significance of Parliament. They did so in public. They gave reasoned judgments. And this was an important statement of the rule of law. And it had its effect not only in this country, but around the world. You know, I travel to do cases and otherwise, and I meet lawyers around the world, and they say, well, we watched that case, and it's very important, and we rely upon it in our courts as a statement, important statement of the rule of law.
Was it really a moment when the courts established or asserted their authority over the executive as the ultimate lawmakers?
Yes, you know, the rule of law requires that somebody has the last word on what the law requires and what the law allows. And those people are the courts. And they did their job, in my view, in very difficult, highly charged political circumstances. But they did their job.
This podcast was brought to you by the University of Law. Subscribe now to make sure you don't miss the next episode.